Thank you for joining us for another riveting episode of Behind Breaking Bond. Andy Kahn with Crime Stoppers, who's usually here with me, is not here. He's possibly in jail with bond set at $1 trillion. Just kidding. He's in Washington, D.C., and joining me today is Chuck Silverman. Chuck Silverman was the 183rd judge from 2019 till
2022.
Also joining me is my good friend, David Mitcham. David Mitcham is the first assistant attorney. David, explain what that is to people that don't know what that means.
Well, I've supervised all the prosecutors that are assigned to all the courts that represent the state of Texas in Harris County.
In a lot of ways, you're sort of like right underneath Kim Ogg, basically.
I report to Kim, and everybody else reports to me.
Tell me what it was like being a judge. Well, you're still a judge.
Correct.
Tell us about that. What are you doing now?
I'm currently an associate judge for the city of Missouri City. So I handle Class C misdemeanors, municipal code violations, and traffic citations. So I'm sort of like the Wapner of TV, municipal courts. But being on the 183rd was the most remarkable experience I've ever had professionally. It was rewarding to have the responsibility given to me by the voters of Harris County, tasked to make the right decisions on some very difficult situations. Is a felony court, and so we tried felonies ranging from state jail felonies, which things like DWI third, all the way up to capital murder cases, including death penalty cases, and it's just a remarkable experience.
That's a hard gig. Being a judge, I think that would be a very difficult job to have.
If it's done right, I found it to be exceptionally difficult because you want to make the right decision within the bounds of the law, and you have a lot of responsibility because you have the defendants, you have the victims, you have the community. It's an awesome responsibility, and to discharge it properly was exceptionally rewarding.
One of the things we've been doing Breaking Bond for about 4 years now. Kim Ogg, DA Kim Ogg, she was kind of one of the first people that publicly said, this is a problem. This is an issue when you repeatedly let someone out on bond and you see that they're continuing to commit crimes.
Well, there was a radical change in bond policy in Harris County that occurred roughly at the same time period you're talking about, and we reported it as best we could to the public, and Breaking Bond has been very helpful in terms of getting out the word on it. It was a real departure from the manner in which bonds were assessed by the courts prior to that. I've been a lawyer 45 years, and I've observed the bonding procedures both as a prosecutor and a defense attorney. Historically in Harris County, if you were on bond for a jailable offense, it wouldn't necessarily even have to be a felony, but certainly with a felony, and certainly with a violent felony, if you went out and were found liable for picking up another serious charge, or for that matter, one that wasn't that so serious, most of the judges would not tolerate that. And I do have recollections of some defendants during that 40-year period or 35-year period before I went back to the DA's office, receiving a second bond after a lot of talking to by the court.
But rare.
But I have no recollection of seeing individuals getting third bonds or fourth bonds or eighth bonds.
And we've seen them go up as high as 16. Now, when you were on the bench, you were known as a judge that wasn't doing that. You weren't letting people out on multiple bonds.
I tried not to do that to the best of my ability. Yeah, sometimes it's you can put them back out if it's a nonviolent offender, and they're caught for some small offense. They for example, maybe they don't come home at 10 o'clock; they come home at 10:01.
Sure.
Or some really minor infraction. In that case, yeah, maybe you put them back out. You allow them to stay out. But in most cases, fool me once, shame on me. But twice, you tend not to get back out there because it's your responsibility to comply with the conditions of your bond. And if you cannot do that, then I don't have any confidence that you're going to continue to be able to comply with new obligations.
Right. Yeah. The way I've always looked at it, and there are people that are wrongfully accused of committing crimes. If I was wrongfully accused, the last thing I'm going to do is cause myself any more harm by getting arrested again. I'm going to walk the straight and narrow.
Well, when you think that the average person can get through their whole life without being charged with a serious crime, you would think anybody that is accused and on bond for one serious charge would be careful not to get charged a second time.
Right.
I was a defense attorney for 33 years, and I used to read my clients the Riot Act about bonds, and that bonds were a wonderful thing, and we're certainly in favor of the defendant being able to prepare for his defense and being presumed innocent. But in exchange for being able to be back in society after there's been a determination that there's probable cause to believe that you probably committed the crime, and to give you the opportunity to prepare for your defense, then you really need to do two main things. One of them is show up in court when you're supposed to show up in court, and two, behave.
Yeah.
Do what the judge just outlined. If you're under rules and regulations by the court, abide by them. And for God's sakes, do not pick up another charge, because the judge could get the wrong idea. And our presumption of innocence begins to dissipate in the face of repeated criminal conduct. There's just no way to get around that logically in your head, that you'd be charged over and over again with the same thing. And in the past, the judges did not tolerate it.
Right.
Now, there was a sea change that occurred around 2019.
Yeah. There were. I can remember judges like Poe. He was sort of no nonsense. He was very fair, but if you tried to pull one over on him, he was. Remember how he'd have people walking around with signs, I stole from this store, or I did this, or I did that.
I was a prosecutor in Judge Poe's court.
Yeah.
I was assigned there in my first trip with the district attorney's office in the early 80s. And Judge Poe and his colleagues would never have tolerated the bonding procedures that are now rife in our courts.
Right. Well, and it was never, when you think about it, the whole idea of bonds was never really anything you saw in the news, right? It wasn't like, and back in I don't know, maybe 10, 15 years ago, if there was a situation where a judge let someone out, let them stay out on multiple bonds, and then they killed someone, that would be a front page headline piece of news. Am I right?
Absolutely.
And it's happened more than 200 times.
It's not news anymore.
Right. And that's sad to me.
They've normalized this repeated criminal conduct. And that's the most disturbing thing about this new perspective on bond, is that you just look at the case in isolation and not in the context that the defendant may be out on several bonds.
Right.
And that's not the way the law is constructed under state law. They're supposed to take public safety into consideration, and whether or not the individual is on other bonds.
Well, what you said before, I've always been a firm believer in this, that as a society, most people are good. And you've got a small segment of people that they're in the criminal element and they're going to stay in the criminal element. Granted, there could be people that they end up there because of addiction and they deal with that. There are people, I understand that people, they change their lives, they go on and they become productive citizens. But don't you think there are people that are in the criminal element that this is how I make a living and I'm going to stay in the criminal element as long as I can?
Undoubtedly. Absolutely.
And there's kind of this whole shift where it's like we can rehabilitate everyone, or that no one should be jailed. We can fix everybody. I don't understand
the
that
defendant
philosophy.
as victim and the system as the villain. That perspective, in my view, has been promulgated in some of our colleges, with the undergraduates and in our law schools, in the decarceration movement that is afoot, and their bumper sticker philosophy is no people in cages. Don't get me wrong, that's a lovely thought.
Right.
But what are we going to do? They have no real answer for what we're going to do with all the misconduct and viciousness that's involved with criminals in our society today. I mean, sadly, we need more jail space, not less.
Yeah, it's almost like let's tear it down, but before you tear it apart, you have to figure out what you're going to do next.
I don't think they have a plan.
Right.
You know, when I was on the bench, it disturbed me to regularly see, in my sense, that the public money is not being spent in adequate amounts to support the criminal justice system in the way it needs to be supported. For example, pretrial services, which is the entity within Harris County responsible for supervising those
watching all these people
out on bond to make sure that they comply with the judge's conditions, and then, importantly, to timely notify the court and the parties of some potential violation of those conditions. That's not being adequately funded. And then similarly, you're not seeing adequate funding to maintain the necessary personnel over at the jail, and you're not seeing new jails being built. And in fact, I think some of the leaders have said we're not going to build any more jails, and which is potentially disturbing to a lot of people here.
But then, what do you do with people that are a danger to society?
Well, you send them to Louisiana.
So, you spend more taxpayer money and you send them out of state.
I mean, it's like just about anything else. It takes funding, it takes money to kind of make sure that there's not, just like you talk about pretrial services, there's no way they could be watching all of these people. And look at the people that commit crimes, well, they've got an ankle monitor.
Well, that was really frustrating to me. Number one, the lack of money and personnel that was devoted to pretrial services in the first place. Because if you have a movement afoot in Harris County, which we do, to put more people out on bond and to get them out of the jails, you need to adequately supervise them, and they're not doing that. Secondly, I mean, you simply need to be able to watch those folks, and there's a false sense of security that's given to the public when a defendant, when somebody says, well, the defendant's out on an ankle monitor. Well, that's all good and fine, but oftentimes you have to remember that has to be monitored, and oftentimes it's not. And in those times, in those situations where an ankle monitor is in fact being timely monitored, the notices of a potential violation have to be sent to pretrial services, to whoever the caseworker is, and he or she is responsible for several hundred defendants at a time, and they don't always see those notices. And oftentimes those violations don't get timely reported to a judge.
Right.
And in the meantime, somebody who you have out on an ankle monitor, could be committing another felony or criminal activity, in which case, obviously it's a violation of the conditions of the bond, but you need to have adequate notice and funding and personnel in order to, adequately maintain that situation.
One of the things that we've been noticing doing breaking bond, I guess in the last few months, you see somebody that they're on bond in Harris County, they're on bond in Montgomery County, they're on bond in Fort Bend County. I've even reported where you have someone that actually serves a sentence where they would get probation for something and they're still on bond. That's crazy to me that you could have a defendant actually serve a sentence while they're out on bond for another charge. But it happens.
It's happened.
It's happening by design. And this would never have happened 10, 15, 20 years ago.
Right.
It's a new way of looking at things. The judge brought out the fact that the pretrial services is inadequately funded. The cash bond business has been vilified.
Yeah.
But they served a function because they would monitor the people they had on bond because they had a financial incentive to do so. Whereas we've taken the bondsman out, but we haven't replaced it with adequate monitoring, and they haven't given the funding to the government agency that is charged with doing the monitoring.
Well, it's a business of trust, right? It's like the bonding company has to have this trust in me that as the defendant, I'm going to come back, or that my mother or my sister or my brother or my cousin is going to be one of the ones that's going to make sure that I get to court when I need to be at court. I mean, it really is a whole thing of trust, because you're basically saying we're setting you free, but you have to come back here and face the consequences of the charge that you have.
Right, and under the present regime, when you have someone on a PR bond or a personal bond in Texas, and they don't show up, well, the court, usually after several resets, will eventually revoke the bond or forfeit the bond. And then a warrant goes out, and then we have to rely on Officer Friendly and his buddies to trip over the defendant by and large.
And that's costing money too, when you have to send people.
Well, they're
out
just
to pick
not
these
good.
people up.
They're overworked too.
Right.
Nobody is out looking for that specific defendant. Under the previous regime with the bondsman, you had a bondsman on the hook for, say, $50,000. Well, they would hire an investigator for $1,500. The investigator would track down the defendant and bring them back to court. They served a function. And what they've been vilified as just parasites of the poor, and the function that they were serving has not been filled by the government institutions. And I can only assume that it's by design that they've done this, and it's contributed to the lawlessness in our society, especially in Harris County. Other counties in Texas don't necessarily have the same problems.
Right.
There's 254 counties in Texas. The problems of Harris County and the problems of Houston are not the same as the problems in Muleshoe. In Muleshoe, they don't have defendants running around on 6 and 7 bonds.
Yeah.
This makes it very problematic in terms of getting anything done legislatively, because the judges around the state, their position is kind of like, well, there may be some awkward situations down there in Harris County, but we're not experiencing that here.
It's not our problem.
And we don't want to upset the apple cart.
Right.
And basically, we attempted to try to get some relief for what's going on in Harris County, and we ran into opposition from the judges across the state because they don't have the same problems.
Right.
And that just made it difficult to get anything done, and we're just kind of hung out to dry here in Harris County.
Some of what we're seeing here is going on in other cities.
In the urban areas, yes. Rural Texas and urban Texas are two different things.
And you talk about PR bonds. One thing I have noticed, I see the judges giving PR bonds not that much anymore. It's the magistrates. The magistrates are real quick to give a PR bond. And you're giving a personal recognizance bond to someone that is a convicted felon. They're facing all of these charges. I mean, that's not the kind of person that you can look at and say, I believe you're coming back. I know you'll come back. Have a good day. Right? I mean, you're taking a big chance.
I found it frustrating many times to have a defendant appear in front of me on the initial arraignment, having come out of magistrate's court with a bond that I considered to be wholly inadequate or granted improperly under the PR rules, or in an amount that was just in my mind not adequate to ensure what you just said, to ensure that the defendant comes back to court.
Right.
And I had really little faith that they would comply with some of the magistrate's orders. So as a judge, you can go over the magistrate and change the conditions of the bond, and in some cases the amount of the bond. But it was, and it still is, frustrating to see what the magistrates do in some situations, and we don't, as judges, we don't have really any control over that.
Right,
that's completely out of our
and
hands.
They don't have to be elected.
They are not elected.
Right.
They're not.
It's, I mean, who are they really responsible for? Who's
responsible to Commissioner's Court. There is a 9-member panel of judges, 3 district court, 3 county court, and 3 JPs that manage and sit over them. But ultimately, they're a creature of Commissioner's Court.
Right.
Just last week on your breaking bond was a really egregious example of that, where you had a defendant on her 5th DWI plowing in while allegedly intoxicated, causing a multiple car accident at a constable substation, totaling 3 constables' cars, as well as put herself and her passenger in the hospital. And the hearing officer's response to all that, and by the way, this particular defendant had gone to the penitentiary for DWI.
Right.
It's their 5th go-round to give a PR bond to that person. Wholly inappropriate.
Right.
Judge Penneguy was on the bench when it came into court, and he rectified
the
situation by imposing a rational bond.
Right.
But these sorts of decisions come out of the hearing officers. They're really not called magistrates. They're called hearing officers.
Yes.
Although they serve basically as
a magistrate. Yeah.
Right.
But a hearing officer.
But we get these decisions out of the hearing officers that are just that do not give adequate weight to public safety.
Right. And as you pointed out, I've seen that a lot, where once the defendant gets into the court, the judge will raise the bond or add more conditions to the bond.
Or in some cases, revoke it.
Yeah, exactly.
Which
yes.
is necessary.
Yes.
But there's not a lot of accountability on the part of the hearing officers to the general public. And there's not a lot of visibility as to what it is, how they're appointed, what their duties are, what their terms are, and who they really report to. And where can you go with a complaint?
Right. You go back to misdemeanor bond reform, right? And the whole idea was, and I think everybody would agree, no one would want to see someone sitting in jail because they couldn't post a bond because they shoplifted from Target or something like that. And the whole idea behind it, I think everybody could get around it. But then all of a sudden, you're basically gutting the whole bonding industry because you're taking their bread and butter away, right? They're not making money off of misdemeanor bonds anymore, so they're losing that money. And then you kind of see where, okay, we'll lower the amount of bond that's needed.
You might want to, yes, and that's a fair statement, but you might want to refocus it, and rather than take the money away, it's a business,
right?
And it served a purpose. And so what you've seen in Harris County is the taking away from a private group into the public realm, and it's not being administered as efficiently or as well as it was in many situations when it was a private group that was responsible for it.
Right. What do you think we need to do to fix it?
Well, one thing on O'Donnell, one of the issues that never seemed to be seriously addressed is, what do you do with a defendant like Miss O'Donnell? You give her the PR bond to get out, and then she goes right back out and does what she was
over
charged
and over
with.
and over and
over and over again. Again, the first bond is one issue,
right?
And significant weight needs to be given to the presumption of innocence and the fact that the defendant needs to prepare for their defense.
Yeah.
But when they go out and do the exact same thing that
she
they're on
may
bond
have had,
for,
as many as 64 bonds or something.
She
was not a good poster child for the whole thing. That's for sure.
She just really wasn't bond material.
She was not.
Given the history of it. But it's this repeat offenses while on bond that has not been addressed. And by the way, the Fifth Circuit was very clear in their decision in the Daves decision that came out a year or so ago that O'Donnell was improperly decided.
Right.
It's like a zombie law. We're still under the consent decree,
yes,
but the underlying case was wrongly decided. It violated the principles of federalism.
Yes.
there's a grand total of 1 county in the United States of America that has federal monitors over their over their misdemeanor bail, and that's Harris County. We're the outlier.
We're running out of time. You two have got to come back, and we're going to pick up this conversation again. Hey, thank you so much for watching this. We really appreciate it, and remember to be kind to yourself and everyone else.